Assalamualaikum and a good day. Private nuisance is one of the most practical areas of tort law because it deals with everyday conflicts between neighbors, noise, smell, smoke, and interference with the enjoyment of land. In this video, we will be focusing on private nuisance caused by order through a fictional but realistic scenario involving residential homeowner and nearby florist business. The sketch you are about to watch is a set in internal law firm meeting where the lawyers analyze the facts, apply legal principles, and consider relevant case law to determine whether a claim in private nuisance can be established. And as you watch, pay attention to show the elements of private nuisance are identified, particularly substantial interference, reasonableness, and available remedies. So without any further ado, let's begin.
Hi, can I talk for a moment?
Yes, what is it?
It's not your flower shop. The smell is very, very smelly. It's unbearable.
But this is a flower shop. It must be smelled.
I'm not talking about the flowers. You have compost and garbage everywhere and it's affecting a lot.
But this is part of my business.
Yes, but it's affecting our daily lives. Guests will complain whenever they visit. My family don't go to the backyard anymore. Like, it's smelly.
Do you ever close the windows?
I can't close the windows 24 hours. It's inconvenient.
But this is part of my business. Did I have any issue before?
Back then wasn't any issue, but now you're leaving it uncovered for hours.
But I don't have so much time on this.
But still, it's affecting our lives.
This is part of my business.
So, you won't change anything?
No.
I won't discuss anything.
Good afternoon. Please have a seat. Okay, tell me what's been happening.
Okay, so there's a florist shop near my house, and they are producing a very bad smell due to the compost and garbage around, and they're not doing anything about it.
Okay, how often does the smell occur?
Every single day, especially during the weekends, because the florist will leave the garbage uncovered for hours.
How does this smell affect you?
It's too smelly to the point where my family can't really go to the backyard, we can't rest and cook properly. Guests will complain whenever they arrive.
Have you spoken to the shop owner?
Yes, but she insists it's part of the business and she's not going to do anything about it.
Okay, he didn't take any step to reduce the smell at all.
No.
Do you have any evidence?
Yes, I have photos and videos and messages.
Okay, alright. You can leave those with me and I will look into this carefully. I think we will get back to you after we make any decision. Alright, thank you.
Alright everyone, thanks for gathering. This morning we have a new inquiry that could potentially turn into litigation. Before we proceed, I want a full breakdown which is facts, law and possible outcomes. So Adriana, go ahead and give us the background.
Thanks Nabiha. So let me start with the fact of this case. Our client, which is Sarah, a homeowner living in a residential neighborhood. Her house is located directly behind Bunga Florist, which operates a small-scale flower and gardening supply business. For context, this business has been operating for several years, and according to Sarah, there were no serious problems initially. The issue only started around 3 months ago. At that time, the florist decided to reduce operating costs by storing fertilizer, compost, and organic waste at the rear of the premise rather than arranging regular disposal. Unfortunately, this rear area is very close to Sarah's kitchen and backyard. During the day, especially in the afternoon, these materials emit a very strong and unpleasant odor. The smells travels into Sarah's house through open windows and ventilation. On weekends, The situation becomes worse because the waste is left uncovered for longer periods. So, the impact on Sarah's daily life has been significant. She struggles to cook, avoids opening the windows, and her family no longer use the backyard. When relatives visit, they complain about the smells, which has caused embarrassment and distress. Sarah tried resolving the matter informally. She spoke to the shop owner on several occasions and asked if the waste could be relocated or at least covered properly. However, the owner responded dismissively, saying the smell is natural, part of gardening work, and that nothing can be done. Until now, there is no steps have been taken by the florist to reduce or prevent the odor. So, the key legal question for us are, does this amount to private nuisance? Is the interference substantial and unreasonable? And if so, what legal remedies can Sarah realistically pursue?
Alright, that's quite disruptive for someone just trying to live in their own home. So, let's revisit the law before we decide to take up the case. So, Miss Mega, can you explain the private nuisance?
Sure, Ms. Nabiha. At its core, private nuisance protects the landlord's right to enjoy their own property without unreasonable interference from neighbouring activities. So, when we assess a nuisance claim, we have to go through several steps. Ms. Shin and I have done our research and gone to Sarah's property. First, we have to assess whether the interference is interference of use or enjoyment of land. This doesn't have to involve physical damage. Disturbance such as smoke, noise, or odor can just qualify. In Sarah's case, the odor definitely affects busy activities. Sarah can't really cook, she can't rest, she can't socialize, which clearly falls within enjoyment of land. Second, the interference must be substantial. So after doing our research, we found out that the law doesn't really protect every minor annoyance. But in Sarah's case, it is definitely persistent because the smell affects every activity that she's done and severe enough to alter how Sarah uses her home. And third, we'll look at reasonableness. Even lawful activities can amount to certain nuisance if carried out in an unreasonable manner. Storing uncovered organic waste next to residential property, especially in hot conditions, is excessive. And finally, the defendant must be responsible for creating and continuing the nuisance. Based on Sarah's statement, Sarah has confronted the florist multiple times and yet no action has been taken. Since the florist chose to store the waste and continued despite complaints, responsibility is clear. So, in our opinion, it is also important we highlight that this is an intangible nuisance, specifically smell, which courts have long recognized as actionable.
Right, smell cases are always fact sensitive. Shiro, how does this measure up once we apply the reasonableness factors?
Well, when we break it down, Ms. Nabiha, almost every factor points against the florist. Starting with duration, the problem has lasted for 3 months. That's long enough for the court to treat it as ongoing but not temporary. Next is the intensity. This isn't a faint smell that occasionally appears, but the odor is strong enough to enter the house and interfere with daily routines. Besides, there's location. The nuisance occurs in a residential area. Courts generally expect business operating near homes to manage their activities carefully. Sensitivity is also important. Sarah isn't unusually sensitive. This would bother most people. On foreseeability, any reasonable person would know that fertilizer and organic waste left uncovered in hot weather with smell. Perhaps the most damaging factor is the florist's reaction. Sarah raised the issue multiple times, but the complaints were ignored. The refusal to act usually strengthened the plaintiff's case significantly. Also, the florist's defense that the smell is natural doesn't really hold. The law doesn't excuse unreasonable interference just because an activity is lawful or common in that industry. Overall, the interference is clearly substantial and unreasonable, and it strongly supports a finding of private nuisance.
That aligns with my thinking. Let's bring in someone who is saying how courts actually handle these cases. Good morning, Mr. Shahni. How have you been doing? My firm got handled a case regarding private nuisance. I have heard that you took up several cases regarding private nuisance before. Do you mind sharing some of experience and information you got from handling the cases?
Hi, hello, good morning. I have reviewed the precedent cases regarding the private nuisance and order. To understand our position, we need to look at the 3 key Malaysian cases that define the boundary between neighbourly annoyance and legal nuisance. First of all is the Ranjan Paramalingam and another versus Persatuan Penduduk Taman Bangsa in 2023. In this case, the court reminded us that nuisance is a matter of degree. It established that for any claim to succeed, there must be substantial and unreasonable interference. Is that clear? The court applied the give and take principle of urban living, essentially minor inconveniences or mere annoyances that benefit the wider community like security schemes don't automatically qualify as nuisance. We must prove our situation goes far beyond a simple annoyance. That is the first case. The second case is Jamaluddin bin Idris and another versus Petronas Dagangan Berhad 2021. This is crucial because it involved odor and fumes. The plaintiffs complained about the smell from a petrol station, but the court dismissed their claim. And the question is why? Because they lack of objective experts' evidence. The court held that in any sensory cases, the burden is on the plaintiff to prove the smell is intolerable to any ordinary person, not just a sensitive one. It also showed that if a business complies with Department of Environment DOE standards, it is much harder to prove they are being unreasonable. The third and most favourable case for us is the case of Wahshan Development Sdn Bhd versus Success Portfolio Sdn Bhd in 2018. This involved the overpowering stench from a pig farm. The defendant argued they were the first a defence court coming to the nuisance, but the Court of Appeal rejected that. They ruled that even a lawful business becomes a nuisance if the smell is persistent and owner fails to take remedial steps, like maintaining the poor buffer zone. It confirms that as an area develops, a business must to ensure its order don't interfere with the neighbour's comfort. Together, these cases shows that while the law protects us from unbearable others, we must be prepared to prove that the interference is substantial, scientifically measurable, and beyond what normal residents should have to tolerate in this specific locality. I hope you understand these three cases, and I hope that my opinion and input might help you in the future. Thank you for contacting me. Bye-bye.
That's very helpful. Thanks for the insight. Strategically, I suggest we start with a formal letter of demand. If the florist still refuses to act, we proceed with the legal action. So, unless anyone has further points, we will move forward on that basis. Thank you. Yes, hi Mega. I heard you wanted to speak with me about your research on the case.
So good morning, Ms. Nabiha. I've done my research on Sarah's case and also regarding private nuisance. So based on my research, private nuisance is kind of defined as an unlawful, substantial and unreasonable interference with a person's use, comfort, enjoyment of the land. So when it comes to private nuisance, there are three kinds of interests that are protected by the law. Number one is the plaintiff's interest over the land. Number two is the use of the land. And number three is the enjoyment of the land. There are also three types of private nuisance, such as nuisance by encroachment, nuisance by direct injury on the land, and also nuisance by interference with the neighbour's enjoyment of the land, which is applicable to Sarah's case. Based on my research, in Project Lebuh Raya Utara Selatan Sdn Bhd against Kim Seng Enterprise Kedah Sdn Bhd, the Court of Appeal reinstated the elements required to establish private nuisance. So number one is the indirect interference with the enjoyment of the land. Number two is the unreasonable interference with the land. And number three is what did the private nuisance cause the damage to the plaintiff or the claimant. So before we start to take on this case, we have to navigate through a few different elements to establish private nuisance. First is substantial interference. So when it comes to interference, in Sarah's case, it is an interference with the use, comfort, and enjoyment of the land. This interference caused discomfort, whereby one is unable to live peacefully and comfortably on one's land due to the defendant's activity. And nuisance is actually a tort which is actionable per se, meaning that the court does not require the plaintiff to prove any sort of special or particular damage to the land. However, the plaintiff must show that the nuisance caused a bit of discomfort or damage. So when we talk about Datuk Harnam Singh against Renal Link KL Sdn Bhd, it's a case that I've actually researched on. The plaintiff had for 18 years operated on a clinic on treatment of nose, ears and throat ailments. And the defendant, on the other hand, operated a renal clinic providing hemodialysis, which is kidney dialysis, treatment which involved emitting obnoxious fumes. And they are located in the same building. And this resulted in the plaintiff, his staff and his patients were found to have suffered substantial damage, ranging from skin disease, red and swollen eyes, headaches, lethargy, and also breathing difficulties, in which case the court had found the defendant liable for private nuisance. So when we talk about this is actually a precedent to Sarah's case, because in Sarah's case, the materials from the small flower shop emitted a very strong and unpleasant smell that drifted into her home. So the smell was so overwhelming that Sarah couldn't even cook in her own kitchen. She couldn't even enjoy her own backyard, and even had complaints from the guests. This constitute an interference with the enjoyment of the land. Although there was no physical and material damage to the property, however, like I mentioned before, in the case of Project Lebuh Raya Utara Selatan Sdn Bhd, the court doesn't really require the plaintiff to prove that there was significant damage. And so the next element that we have to prove is that unreasonableness. So there are actually 5 types of unreasonableness. First is the damage and location of the plaintiff and the defendant's premises. So in this case, the court will actually take into account and they will assess the damage done to the land itself, and they will have to talk about the location and premises are also consideration regarding this case. In this case, Sarah and her neighbors are actually beside each other, so the interference of the land is quite near. In Bliss against Hall, the plaintiff moved into the house near a factory, but the defense from the defendant's side was that the factory has always been operating even before the plaintiff moved right beside the factory. But the court reinstated the plaintiff's right, stating that the plaintiff also had the right to clean air. The next is the public benefit of the defendant's activity. If the object of the defendant's conduct benefits society generally, then the court will not really deem it unreasonable. However, in Sarah's case, the flower shop does not provide public benefit at all. The third one is extraordinary sensitive on the part of the plaintiff. So in this case, the court will not really be sympathetic to the plaintiff. It is extra sensitive. For example, if the plaintiff complained due to skin or health issue, then the claim might fall. However, in Sarah's case, she did mention that there were even some guests that complained of the smell, so maybe we can get statements from the guests themselves too. And in this case, if there's already substantial and unreasonable interference, then the sensitivity will not really deprive of the plaintiff obtaining remedy. The third one is temporary interference and isolated incidents. In this case, the court may be reluctant to grant an injunction or provide remedy of the nuisance if it is not continuous. So, which brings us to our 5th type, which is the interference must be continuous or occurs very often to constitute a substantial interference. So, in the case of Lai Kong Lok and another against Ting Si Ling, the plaintiff alleged that the defendant had always parked his vehicle in front or near the front gate of the plaintiff's house. So in this case, the plaintiff claimed that the defendant's continuous parking caused the defendant inconvenience and also obstruction for them to exit and enter their home, which caused them a lot of mental and physical distress. So in that case, the court held that the defendant was liable for public nuisance and private nuisance, taking account of the defendant's conduct and the fact that illegal parking was still continuing. So I think the 5th element of unreasonableness is kind of the best approach we can take in Sarah's case, because the smell emitted from the materials was so strong and unpleasant. Even the guests complained, and also Sarah had approached the shop owner several times asking him to store it elsewhere or manage it differently. However, no steps have been taken to reduce the impact. So the continuous discomfort are relevant considerations that should be taken account into the private nuisance claim. So regarding this research, I think we have a few cases that we can use as precedents to strengthen Sarah's case, and also we can proceed with the private nuisance claim since Sarah's case fulfill all the elements of private nuisance. Thank you.
Based on your research, I will explain to you about the remedies, and I need you to inform this information to the others. So Sarah has strong grounds for a private nuisance claim. Since the nuisance is ongoing, remedies that prevent future harm are more suitable than remedies that merely compensate for past loss. First, Sarah may seek an injunction. An injunction is the most appropriate remedy because the nuisance is continuous. Bunga Florist continues to store fertilizer, compost, and organic waste in an improper manner, which causes strong smells that seriously interfere with Sarah's daily use and enjoyment of her home. As the problem is recurring, damages alone would not be sufficient to resolve the nuisance. Second, Sarah may also claim damages. Damages are awarded to compensate for the discomfort and inconvenience suffered. In this case, Sarah is unable to use her kitchen and backyard properly and has lost enjoyment of her home. She has also experienced embarrassment when guests complain about the unpleasant smell. Therefore, Sarah is entitled to monetary compensation for the harm already suffered. In conclusion, Sarah may seek both an injunction to prevent future nuisance and damages to compensate for past inconvenience. That's all. I hope you inform all of this to the others, okay? Thank you, Mega.
As demonstrated in the sketch, private nuisance is not about whether an activity is lawful, but whether it is carried out in a manner that unreasonably interferes with the neighbour use and enjoyment of land. In Sarah's case, the persistent odor from unmanaged fertilizer and organic waste clearly crosses the threshold of substantial and unreasonable interference. Specifically, in residential setting and after repeated complaints were ignored, the discussion also highlights how courts balance competing interests, allowing business to operate while protecting homeowners from avoidable harm. Ultimately, private nuisance serve as an important legal tool to maintain fairness and harmony between neighbours, ensuring that one party's convenience does not exclude expense of another's basic comfort and dignity. And with that, thank you for watching. Assalamualaikum.